order. Let's continue with number 10,
11A.
number 11, substance use awareness.
Page 228.
Okay, diversion report.
Good afternoon, board members. So my presentation now, starting again, would be agenda item number 11, diversion. So the diversion statistics are for quarter ending of June 30th of 2019. And as you can see, there hasn't really been too much of a change. As of June of 2019, we have 14 active participants. And so for that quarter, we had 3 participants that cases were closed. So we're at 14 right now. So that's no change, and that's pretty much a short report on this, unless someone has any questions, diversion.
What's the budget for that?
That is a good question there for the budget on this.
Thank you. Good diversion there.
The participants pay for participating in the program, but the board does subsidize the participants. So I believe that the participants pay, let me get this backwards, $100 a month, and it's around $342, and the board subsidizes the additional money. We are in the process of putting together the request for proposals because the contract with Maximus ends at the end of this year. Hopefully the executive office will be working with Maximus to extend their contract perhaps month by month, because there certainly needs to be a transition period. And from what I understand, the request for proposal hasn't even been posted yet. So it was actually supposed to have been posted in March, and there have been a number of delays. So I'll report back to you. But typically our numbers have hovered for the last number of years around 14 participants. Mm-hmm. When the dental board started with the program, it was more like 89 participants, so it was
80,
higher.
And that was in the 80s.
Right.
So is that because people don't want to come forward, or we don't?
Well, we've heard that.
Offer that?
We've heard anecdotally that it's somehow related to uniform standards, and that, there are not as many referrals of people of their own realizing they have a problem and want to go into the program. They typically go in prior to an investigation being complete. So.
It's just drugs and alcohol, any other?
It's drugs and alcohol,
Just
although the
only
program does cover mental health, but typically we're looking at drugs and alcohol.
Thank you.
Mm-hmm.
CDA, what are your numbers like?
Mary McCune, CDA. I don't have the numbers offhand, but I do know they are really low, so we can get those to you at the next meeting.
Right?
Yes.
With that said, could you possibly, I would like to have a better understanding as to how the board's diversion program and CDA's wellness program interface with each other, or do they?
They don't. They're separate programs.
I know they're separate programs, but do they communicate with each other?
No.
So the board does...
They're very different programs. CDA's wellness program, you'll recall when we had the presentation by Dr. Vixie, and we could have a refresher course on that, but their wellness program is structured very differently than our diversion program. And there's no statutory requirement for CDA to make referrals to the dental board of whoever gets into their program.
questions, I'll move on. So now to agenda item 11B, and it's an update regarding the June 11th, 2019 statewide opiate safety SOS work group meeting. So at this meeting, it was introduced that the California dashboard was updated with all new information now and data. So information and data is now available from 2006 all the way through 2018 now. And so what it has, you can find data. You can select it by gender. You can select it by age. You can select it by a certain area in California and counties. And it gives you information of all drugs, prescriptions, opiates, any opiates. And so they have now information that you're seeking for new indicators with mortality rates with opiates that were combined with other drugs. And so there's new data now available for emergency department visits, hospitalizations, same thing, prescriptions that were written, and they also have now cures as well. So they, on this dashboard, you go in, log on, and you can also get cures as well. And as soon as you log on to the dashboard, it automatically populates. So all the new information automatically populates, so you're aware that there's new information now on this dashboard. So, so anybody that's interested, like all the data has been updated, and it goes through the second quarter of 2018 mortality. There's 2018 mortality data available. There's time trends. There's bar graphs now and tables that illustrates all the numbers, all the information for this. So it's great information that's been posted now on there. Also, there's they introduced for first responders now as well. First responders responding to fentanyl overdoses. There's some concerns where they felt is fentanyl able to get onto the skin when you're treating fentanyl overdoses. Are you able to contact fentanyl through contacting the skin? So the Department of Department of Healthcare Services presented a draft to the SOS work group meeting. It's been finalized. And so it's how to respond with fentanyl overdoses, including management and suspected overdoses, and resources, obtaining naloxone, and also discussions. So in 2017, the state had 429 fentanyl-related overdose rates, which was an increase of 81% over 2016. So there's been concerns. And so the American College Medical Toxicology and the American Academy Clinical Toxicology also presented detailing scientific information for first responders. So according to those two entities there, so incidental skin observation is unlikely to cause clinical signs of toxicity. Nitrile gloves provide sufficient protection for routine handling. Simple washing with soap and water is adequate to remove the fentanyl from contaminated skin. Also, one of the things that here was important was hand sanitizers and cleaning agents may increase the absorption and should not be used here. So soap and water is better than the hand sanitizers. And so then when drug particles or droplets are suspended in the air, they also said that N95 respiratory provides sufficient protection as well. And the risk of clinically significant exposure to emergency responders is extremely low. And also the management of suspected fentanyl overdoses. Fentanyl produces characteristics opiate overdose signs and symptoms, including decreased level of consciousness, slowed breathing, lack of response to stimulation, and constricted pupils. So there's more training that on now for first responders or anybody responding to any type of overdoses, where you can go and look at these symptoms and kind of make some of a conclusion that they're possibly overdosing on fentanyl. And also peak respiratory depression can occur within 5 minutes or less. Therefore, rapid response is imperative. And again, the number one thing that here is the naloxone administration. Like I said, that's the number one thing. All the resources that everybody's doing now, they're now, again, police agencies and, as you know, corrections are now having this now when they're having a fentanyl overdoses. So as you know, you give naloxone, and it counteracts the overdose. It kind of brings you back and stimulates you back into it. So, so that's the number one thing here is that naloxone that helps everybody out. And also the California Poison Control is a resource as well that you can contact to get more information on the management or the information on overdosing on fentanyl. So that's available now as well. And so the other thing that was introduced, and this is an action notice, a letter that's being worked on by SOS. Still, it hasn't been finalized, but they're calling it a health alert, and it's don't drop your patients. So one of the concerns is that if a physician, if you have a patient that walks in and you're treating this patient and they have, you're presumed that they have opiate dependency, they're struggling with this possible substance addiction, their thing is don't drop them as a patient, and what you try to do is you try to help them now. And so what the you know, one of the resources is to include is consider all pain management options before starting the patients on opiates, also recognizing and understand how to taper down on the opiates, and offer medicated assisted treatments to your patients, so a MAT. So that's the letter that they're working on right now. So the important thing is, if they have these indicators, is not to drop them, and it's actually to help the patient now with that. And that was introduced in this meeting. I have any questions? Yes.
Carlos, in the work group, did it distinguish let's see how to describe this, an unsupervised use of fentanyl versus supervised in terms of mortality and morbidity?
If you could repeat that again, I'm sorry.
Okay, so the implication of fentanyl in either overdoses for mortality or morbidity, did it distinguish between unsupervised use, meaning illegal or illicit use, versus supervised use of fentanyl?
It does, it has the indicators there with prescription fentanyl, and then fentanyl that wasn't prescribed at all. So there is indicators that separates it there. Then also, like I said, there is combinations, fentanyl with other drugs that cause the overdose. So it gives you a breakdown. So you could actually, on this dashboard, you could put any drug out there, find information if it was combined with any other drugs as well.
And the other variable that comes into place is the counterfeit fentanyl that comes out of China. Does that come into play?
That hasn't been discussed regarding the counterfeit fentanyl, but I know it's out there, and because there is alerts out there that, you know, like you said, people are now manufacturing it and selling it, and those are those there are the most dangerous ones, is the ones that they try to copy it, make it, sell it. Those are the most dangerous ones. If not, I'll move into agenda item number 12, and it's a discussion regarding vein punctures. So at the last dental board meeting, Dr. Laren asked to consider the future agenda item regarding the procedure that's being used in dentistry, which is platelet-rich plasma therapy, you know, PRFs, PRPs, and indicated that this procedure is being done more by dentists. And so one of the questions came up is whether dentists need a phlebotomy certificate, or does fall within the practice of dentistry in 1625. And so with the PRPs, PRFs, you know, the therapy, it uses injections of the patient's own platelets to accelerate the healing of soft tissue and bone regeneration. And so it's made by drawing small amounts of blood from the patient and spinning it into a centrifuge. And so now, like I said, the question came is, does the dentist need a phlebotomy certificate to draw blood for PRPs, PRFs, or does fall within the scope of 1625? And so neither blood draws or PRPs, PRFs are explicitly described in the Dental Practice Act. However, staff believes that the statute is written broadly, so it allows blood draws for certain dental procedures. So therefore, licensed dentists are capable of performing blood draws for PRP, PRFs therapy procedures. Now, the action is if the board finds that blood draws are valid portion of surgical procedures described in the statute and feels that further clarification is necessary, it could adopt a regulation that establishes blood draws as within the scope of practice of dentistry and describe the parameters and situations in which licensed dentists may perform a blood draw.
I wanted to add before we got the discussion going that staff does not believe that this is necessary. They believe that 1625 is written broadly enough for dentists to do the blood draws. The phlebotomy certificate actually references drawing blood for testing, and so dentists aren't drawing blood for testing per se.
Well, the underlying premise here is that if a dentist does any procedure which they're licensed to perform, they have the knowledge, skills, and ability. So if you're going to do it, know what you're doing. I think that goes without saying. So if you need to take a course, go take one. I mean, you know, I trained in a hospital setting as a medical intern. I got my training there. Others may not have. But I think, you know, if it were to come up as a disciplinary case, that would be what they're looking for.
I wanted to ask you a question about this, Lilia.
We just want to clarify that at the dental board, if somebody calls that this is allowed, that they do know that
Can
this
you
is
speak in
allowed.
the mic?
Well, we've just been getting conflicting answers from the board, I guess, the people that have asked me about this. So as long as it's clarified that they are allowed to do this procedure, I mean, that's fine, if everybody's aware of that. And I also wanted to ask, because I know it has come up in disciplinary cases, in dental school, how much training do we have for these procedures? Do you know?
As far as dental schools in general are concerned, I can't speak to that issue. I can speak to one. As far as our pre-doctoral dental education program, I'm not aware of students being trained specifically in drawing blood. They are trained in the anatomy of the forearm and the location of blood vessels, arteries, veins, nerves, in the anatomical area where the blood draw would be most commonly taken from. But I'm not aware of any formal education in or practical clinical experience in drawing blood. You know, and I agree with Dr. Witcher in that, and staff, that the code, I think, covers that procedure as being under the license of a dentist. However, that every dentist has the responsibility to be confident in doing what they are doing, and if they don't, then they need to get some additional training and education. But I don't think it's necessary for us to change our code or to make a difference. I think it's covered all procedures necessary to treat conditions and diseases of the teeth, the gums, and the supporting tissues, structures, are covered in our code. And that's a procedure that is, when this code was written, I'm sure that procedure wasn't even in anybody's imagination, but it is now. And it is not an uncommon practice. And as a licensee, we have the responsibility to make sure that we have the skills, the knowledge, and the ability to do what we're doing.
So when somebody calls the dental board, they will know to answer that this is allowed.
I'll reiterate that our staff is not supposed to be confirming or denying an interpretation of statute. They're supposed to be saying, I'm sorry, I can't give you that information. Perhaps you can check with the association or your insurance company, or you can get a legal opinion for that. But our staff is not supposed to be advising. So if you have recent knowledge, and this is for all board members and stakeholders, if you have called our office and have gotten some advice, please try to get a name so that we can get to the root of it. But in our research, essentially, this information hasn't been disseminated since 2011. So we didn't know of any recent calls or advice that were given since 2011, and that's when we changed the process. So we will go ahead and continue to train our folks. Certainly we'll let them know what this is, but we would prefer them not to give advice, and that just keeps it a little simpler.
I just want to thank you for bringing this up and clarifying this for us. Thank you so much.
I don't have an issue with the statute itself, but just for my clarification, I learned venipuncture in the hospital also. Venipuncture, how's that distinguished from phlebotomy? Because when you start an IV line, it's venipuncture. So I need maybe some clarification on what a phlebotomy certificate is versus just venipuncture. I think you need practical experiences before you start doing any of that.
I guess my response to that is, not being a practitioner, it's pretty clear to me that when you talk about phlebotomy, you're talking about drawing blood, not using it for some other purpose. And so I have to understand more why you think it's not clear.
I agree. Phlebotomy is withdrawing body fluids. The venipuncture is just the act of penetrating through to the veins. You're delivering something, but that seems like a greater category than phlebotomy. And phlebotomy is pretty invasive, actually. If you don't know what you're doing, you hurt somebody.
And we may have used the wrong term. I mean, I think the question Dr. Laren was asking was, can dentists draw blood for use in this therapy treatment? I think, so I mean, staff, may have used terms that we shouldn't have in terms of looking at venipuncture and phlebotomy. The phlebotomy certificate, I believe, by definition, is the drawing of blood for testing purposes. I think that's, if you go to the website and check, that's what they're saying. The phlebotomy certificate relates to drawing blood for testing purposes. But we can look further into that, but I think that I hope we've answered Dr. Laren's question, was initially she had said that different people calling in were getting different answers to the question of whether dentists could draw blood to use in these therapies.
No, all we wanted is a clarification.
Okay.
Yes or no?
Okay.
Okay, and they, by they you mean?
It was a CE course at UCLA. that was requested this information.
I'm sorry.
UCLA CE course. They want to provide the course, but they were worried about if this was allowed, the phlebotomy, and they called the board and got two different answers.
Anything else on that? Is that up for future purposes, or did you have another question?
I don't want to get that far afield, but drawing blood can also mean needle stick for our testing for blood sugar. Is that phlebotomy? You're drawing fluids. Go ahead.
Yeah, I think what you're referring to through the chair is that that comes under, then you're into the CLIA laws. which have specific requirements. It's not taking the blood, it's what you do with it, where you are now submitting it to a laboratory test that is subject to regulation under health and safety code. And, we've run into trouble with that because, there's a lot of in-office testing available now. What we do is we have the patients bring their own glucometer and they use it.
Anything else on that? Any public comment?
Hi, Dr. Guy Atchison, California Academy of General Dentistry. I want to go back to Cures 2. In the beginning, it was difficult to determine how dentists who have DEA licenses were complying because we didn't know how many had DEA licenses. So this is the first time I've seen these numbers. 24,633 California dentists have DEA permits. But still, only 15,000 are registered. That's 60%. And we've passed the 3rd year anniversary on this law. So I'm just curious, who's responsible for enforcing this? And is there any intent to enforce this? And is there a way that perhaps the relicensure of dentists is tied to this if it's required? It's just 60% compliance at 3 years doesn't sound very satisfactory. So that's my question. Who enforces it, and is there an intent to actively enforce it?
I'm just waiting to see, because this agenda item we already spoke on.
Okay.
And so I need clarification for whether we answer or not, because we already covered this topic.
Okay. That's okay.
Okay, I'm sorry, I'm a bit distracted here because we had moved on past that agenda item. So you're referring to agenda item,
Right. I was waiting for a public comment.
okay.
request.
All right. So Michael, are we good to go
Yes.
back to the agenda item? Okay. So in response, there's no way for us to know who has a DEA license and to monitor whether people have registered.
And let me jump in with the numbers that we have from DEA. Those were the last numbers that we got when we started this whole process, and as discussed in other prior meetings, unfortunately, now I have tried to obtain up-to-date numbers of how many are actually registered with DEA, they're allowed to prescribe, have licenses, but they won't share that information. So that number there could either be up or low on that. Unfortunately, they just won't share that information.
And so we enforce it only by way if a complaint is obviously submitted to us. And if any complaint is submitted, part of the checklist that investigators look at is if they have a DEA license and if they've been registered. And you're smiling, but
Thank you.
Which item are you,
11A.
big one?
I wanted to respond to 11A when you asked CDA how many participants were in our wellness program. So I have data from 2017, and it roughly averages 30 participants a year. And there might be some duplicative numbers in that, but we average about 5 graduates a year, at least until 2017. So if you wish, I can give you more updated information in November.
Thank you. Okay, any other questions? Thank you. Okay. any more public comment on items 10 through 12? Seeing none. Thank you. And we are moving on now to item 13, the overview of the disciplinary. We're moving now to item 13, the overview of the disciplinary process.
Okay, I'm going to be presenting this. We had a couple of board members that asked us to revisit the overview of the disciplinary process, and this essentially takes up, after the complaint has gone through the investigation, it's referred to the Attorney General's office, and what's developed in the Attorney General's office is called the pleading or an accusation. And that's essentially when the process starts to go through the series of things that I've outlined here. One of the questions might be, what's a default decision? So you'll see in the second paragraph, once an accusation is essentially sent to the respondent has 15 days to file a notice of defense. If the Attorney General's office doesn't hear from the respondent, then we move forward with a default decision, and then that's what the board is voting on. Essentially, we filed an accusation, we got no response from the respondent, and so the default decision goes forward. Does anybody have any questions about that so far? Okay. So as the accusation goes through the process, assuming the respondent has filed a notice of defense, then we can start negotiating terms or determining whether or not it's going to go to hearing. We try actually to resolve issues before they go to hearing for a number of reasons, for time constraints, money on all sides. And so if we can reach a settlement prior to going to hearing, that seems to be a good thing. So I, on behalf of the board, negotiate the settlement terms, and the settlement terms mirror our disciplinary guidelines. And I believe board members all have a copy of the disciplinary guidelines. It essentially outlines what the highest level of discipline would be, and then essentially the lowest level of discipline. So the highest level of discipline would be revocation, and then we sort of negotiate down from there. So a stipulated settlement is an agreement, essentially, of the terms. And then the board has to vote on that to see whether or not they agree. And so what we do in closed session then is, on some cases where the board holds for discussion, sometimes those settlement terms may change, and so a counter offer is oftentimes given back to the respondent. Are there any questions so far about going through that?
I have a question.
Go ahead.
How did we arrive at the number 2 for board members that would vote to hold for discussion? Out of 15 members, how did we arrive at 2 as being that number?
I think we're going to have to research that. I'm not sure how we arrived at 2. So we'll get back to you on that. Did you have a recommendation that it should be more or less, or?
Certainly, it certainly is a majority to approve. Oh, sorry. There you go. It certainly, 2 to hold for discussion is not a majority out of 15 board members. So it seems like a pretty low number to not accept the proposed settlement.
And so,
That would not be a successful vote if we were voting to approve or deny a motion around this table. To oppose would not negate the vote. So I'm curious, it seems to be a low number, let's put it that way.
but the number is only for discussion. It is
Right.
not for,
I know that, but I'm just saying that that's a low number to even hold for discussion. Certainly is not a,
I'm going to ask the same question then that Karen asked. What are you suggesting?
I'm suggesting that we revisit the number of votes necessary to hold for discussion And I'm curious to know how we arrived at the 2. It was something that was in existence before I became a member of this board. And I'm just curious as to how we got to that number.
We'll look into it. We'll see if we can find out.
Thank you.
Yeah, I guess I'll just state the contrary. I would not be in support of raising that number any higher. I think we have really good discussions, and if someone feels strongly that we need to hold it and discuss it as a group, I think that's really important because we're doing these kind of remotely to begin with, as opposed to having to bring them all into the meeting. So I would definitely not support raising it. You know, if there's an argument for 1, I can see potential for that, but I understand or at least mentally or objectively understand for 2, and I wouldn't want it higher.
I'm going to repeat the wisdom of counsel here, because I asked that same question, and he said it's not a matter of law, it's a board's decision. And I absolutely agree with you that I would not like to see some majority. I think that I've seen over time kind of quite the contrary, where maybe only 2 people may disagree and everybody else has agreed, but the discussion has led people to rethink things. So I absolutely agree. I would not want that to go to a majority, but we can honor your question and see if we can find out what the answer is to that.
So I'll just draw your attention to the second paragraph on page 2 of the memo, but page 235 of the whole packet, where the factors that are considered during the settlement conference encompass a number of different things. It's the seriousness of the charge, the volume and scope of the charges, how recent the charges are, how many patients were included, the intent of the respondent, and the mitigation that's submitted, or the rehabilitation. Typically, if a respondent submits CEs or something, those really don't sway me in my decision, because it would be up to the board to determine whether they want more extensive remedial education. So also letters of reference don't typically hold a lot of importance in the discussion, because oftentimes the letters of reference don't even really know what the accusation was about. They're more of a personal character reference type of a thing. So that's how I go about determining. And it's just then to see what the negotiations will come up with. If we can't come to a reasonable settlement, then it does go to hearing. But in all cases, the board votes on how to move forward. Now, we've had sort of a rash of requests for reconsideration or petitions for reconsideration, and those get kind of complicated in terms of what you're voting for. And so I'd like to try to clarify that, and in doing so, I think what we'll have our legal do as those cases come up to try to walk you through it in individual memos as they come up, because we don't have them a lot, but we've had a rash of requests for reconsideration. And a request for reconsideration typically comes from the ALJ's decision that the board has voted on. And so once the board has made that decision, then the respondent has the ability to ask for reconsideration. And the board then would discuss or would vote on whether or not to reconsider. I would say that most likely it's rare that you would reconsider, because the ALJ's thinking is pretty clearly outlined in the proposed decision, and the board is reviewing that as they're deciding whether to uphold those decisions. So unless some of the reasons why you would say yes, you would go along with a reconsideration if you felt some sort of technicality existed in the argument. Agree with that?
Just to add to that, a motion for petition for reconsideration could come from either the respondent or the Deputy Attorney General. In many cases, a respondent has the procedural right to ask for it and may just ask for it as in a matter of course. But there could be other situations where either the respondent or the Deputy Attorney General, after the case has been decided, becomes aware of some fact or law that may change the decision. Those are the type of cases where you may wish to grant a reconsideration. And in brief summation, the reconsideration has to be requested before the decision takes effect. A stay of up to 30 days can be granted to prepare that. The staff can also grant the board an additional 10-day stay to consider, forgive the double word use of the word consider there, to consider the petition for reconsideration. But on the back end, if the board takes no action, the motion to reconsider is deemed denied. So the decision that you made continues to take effect without obstacle.
Right. And we have had one example of the Deputy Attorney General asking for reconsideration, the Deputy Attorney General representing me. When there was a proposed decision, the ALJ was hearing the case and I believe did not appropriately apply uniform standards because the case really didn't mention substance abuse or alcohol abuse, and yet these restrictions were applied. And so a number of years ago, that came to my attention and I asked the board to reconsider. The board did reconsider and adjusted the terms appropriately. So that was a rare case, doesn't happen very often. So are there any questions about petition for reconsideration?
I just wanted to back up to a nuance, unfortunately not on this topic, so if anybody has any questions, let's take that first.
One question. A lot of times it goes to ALJ. Is there a governing body that calibrates the ALJs? Because we have so many. Because you can go to one ALJ and they have told, let's say they're new on dental, they know exactly nothing about the case. So is there a body that kind of gets them together and discusses things about our cases?
I don't know of a body specific for that purpose. The Office of Administrative Hearings is run by a presiding judge, and that presiding judge reports to and is a division of the Department of General Services. I believe, and I hope they have training that covers those aspects, but I'm not aware of a specific body that.
Because if somebody
that
comes
does
from
that.
a judge from a different board comes to our board and it's totally on opposite sides of the spectrum, how are they supposed to rule on certain things that may not pertain?
Well, they rule based on our disciplinary guidelines. So the
Exactly.
ALJ is
Exactly.
using our disciplinary guidelines. But we could look into this. I believe years ago, the dental board actually may have provided training to ALJs in some of the dental issues that come up. So I can look into that and then we can report back.
You're mentioning that you had a rash of, do they offer a reconsideration at the end of the discussion, or was it all of a sudden, oh, well, yeah, maybe we should look at it again, and maybe they don't know what the aspects of what we already ruled on?
Well, so all proposed decisions come to all of you board members, and you determine whether or not you agree with the proposed decision or offer your decision, essentially. The reconsideration, the petition for reconsideration comes from the respondent. So the ALJ is out of it at that point, And so the petition for reconsideration would come from the respondent.
And their attorneys. The
And their
attorneys
attorneys,
probably
yes.
said
Yeah.
you can do this. So
Yeah.
that's where it comes from,
Yeah.
probably. Okay,
Yeah.
I understand now.
So typically, the petitions for reconsideration are for revocations, for denials of reinstatements of licenses. Those are primarily what you're looking at.
Yeah, going back to page 1 there, the last line talks about how the settlement can be discussed directly with the respondent and counsel, or there can be an informal conference presided over by an ALJ. When do we decide to use an ALJ to preside over a settlement conference? I know we do it, but are there specific things that have to happen, or?
We don't do it.
Oh, okay.
So I don't know, and Michael, we can see what your experience. Some cases have a mandatory settlement conference, and some don't. So I don't know who determines that. So that's another thing we can go look into, unless, Michael, you can add something to that.
I think I can. I can't discuss the settlement conferences, the procedures for that in detail, but there are procedures for that in the code for a formal settlement conference before the ALJ. That would generally be something that one of the parties proposes, perhaps the respondent, but also certainly Ms. Fisher could also propose that, and I would guess that those occur in complicated cases where you want a neutral party to try to work out a settlement.
I think they're
Is that a
valuable.
good statement?
Yes. Yeah, I think they're valuable. I think so what happens is if you have a mandatory settlement conference before the hearing, it means that the two parties come together and an administrative law judge listens to the argument and tries to get you to agree to some settlement prior to going to hearing. Sometimes that doesn't work, so sometimes you still go to hearing. But we don't appear to have mandatory settlement conferences on all our cases. So I can look in to see how that works.
It's just interesting, because I do think it's helpful at times to have that third party there, especially if they're a seasoned person, and in the more complicated cases. And, you know, they don't come up very often, but every once in a while you look at it and you kind of wonder, okay, well, yeah, this was a good idea, but, you know, when do we do it and when don't we do it? And so anyway, we'll get that answered.
So just taking a look in Government Code Section 11511.5, they are initiated by the motion of a party or by order of the administrative law judge. So they're not mandatory in every case, but
Yeah, it's different, like in a civil procedure where you have a case management conference and some other procedural things. This is administrative, so.
Well,
I mean,
we just recently had a unique case. So we had a settlement conference 2 weeks ago, and then another settlement conference scheduled from that one. And then coming down here, as luck would have it, as soon as we get in the car, the ALJ's on the phone and wanting to discuss certain things. And she then says, okay, we're going to have another discussion in 2 weeks. So she really is trying to get the parties to agree on this. So, but that's an unusual event that we have somebody so determined to really try to find an agreement. So, and I did have one ALJ that didn't think we should go to hearing on a death case, and she made the comment that she didn't think that it was appropriate use of taxpayer funds. And on the tip of my tongue, I was going to say, but Your Honor, the taxpayers don't pay for that, but I chose not to go down that road. I didn't think it was appropriate time to educate her. So anyway, but thank you for that question, and I can come back, I can circle back around and come back with more information. Are there any questions so far? Dr. Stewart, you were one of the folks that asked for an overview. Is there anything in particular that you had a question about?
I'm recalling a conversation, I might not exactly have this right, but I believe I heard a statement, something to the effect of, there are stipulated decisions, there can be a proposed decision, but there are some nuances in terms of how those decisions could affect somebody's probation. And so I was trying to understand what that meant. And so I thought maybe a review of these terms and exactly how they work
Okay.
could be helpful to all of us.
I was considering, I'm still considering putting together some sort of, I don't know, we'll call it a glossary maybe, of what the term is and a simple explanation of what it is. Sort of a cheat sheet, fit it all on one page so that you can refer to that. But a stipulated settlement is just that. It's an agreed upon. A proposed decision actually has gone through a hearing. Okay? And in both cases, the board still is the final decider of it. Is that helpful? Now, with regard to probation, you can have probation in both cases. Typically, what we negotiate in a stipulated settlement is either a public reprimand with additional terms, perhaps cost recovery and maybe a remedial education. But probation, then, you are actually assigned a probation monitor. You check in quarterly, you send in probation costs, in addition to whatever you've been required to pay back in cost recovery. So there's really, that's how probation, so public reprimands are not probation. Settlements that include probation are, and then the proposed decision could be either or none. I mean, we have had cases that have essentially been dismissed from an ALJ. We try not to have that happen a lot, but there were two by one particular DAG that happened to occur, so he doesn't represent us anymore. Is that helpful, or are we getting
Yeah.
closer to
No,
understanding?
this was very helpful.
Okay.
So thank you.
Lilia?
Yeah, hi, I just want to thank you, Karen, for putting this together. It's so helpful for the new people on the board.
Okay.
But I did want to ask about the abstain vote. I don't see it on here. My understanding is the abstain vote is only for people that have a conflict, that might know the person that's being disciplined. I just wanted to clarify that, or can you abstain just because you don't want to be involved with a certain case, or?
Michael, are you comfortable responding to that?
So part of what your question brings up is the difference between recusing yourself and an abstention vote on a particular matter. The recusing oneself would be a situation where a board member has some sort of financial interest in a practice, let's say, that's where one of the licensees is being disciplined, or knows the licensee to some extent and wants to recluse themselves to have that appearance of impropriety taken away from the board's decision. But certainly an abstention vote can be voted, I would presume, on a disciplinary matter if someone wants to just participate in the decision but abstain from the vote. And that is a matter of a board member's discretion to determine how they vote.
Are you good? Oh, no? This is your, if you're not, just keep, because
No, it's
I'm sure
just
other
that-
board members might be a little shy and they may say, oh, Lilia, keep asking. I'm not quite sure on that.
No, it's just that I was told that the governor selected you because, he wants you to vote, not to abstain. I mean, that's something I heard, but I just want to clarify that part. I did think it was just because of conflict of interest. I didn't, but I have seen that it's some of these abstain votes are possibly not conflict of interest, or so maybe you can't just abstain if you don't like this particular case.
Yeah.
You do, I mean, you can do it, I guess, yeah.
Well, we did have one board member who wanted to know what county each of the decisions occurred in, because she wasn't comfortable making a decision on somebody in the county. I guess one could argue whether that was taking it a little too far, but I don't know. It's not for me to decide. Board members have that option. I mean, if you're not comfortable, you need to follow your heart.
Oh, no, thank
But
you.
your board,
Yeah, thank you.
your vote is not public in the way that it
Oh,
would
yes,
be
yes,
public
yes, I
in
understand. Yes,
other.
I understand, yes. Thank you.
Right.
I don't want to belabor this, but going back to the government code, could one make a case for someone who is representing themselves, for instance, and looking at the government code and saying, geez, I didn't realize I could do this. And I'm not satisfied with how this turned out for me. And so I want to claim that I didn't get due process because I didn't understand the process and therefore may have had a fool for my own client. You know, it just.
In terms of a pretrial settlement conference?
Right. Mm-hmm.
Ultimately, these are mechanisms negotiating and arriving at a stipulated settlement or doing a pretrial settlement conference. These are mechanisms for administrative judicial economy to really save the money and expense of time of going through a whole hearing. But ultimately, every party will be entitled to a hearing, and the hearing is the due process by which they will have their quote-unquote day in court, be able to present whatever evidence they need. And ALJs are really admonished to, if you have someone who's unrepresented, assist them in that process of presenting the evidence, testimony, even to the point of asking them questions to help bring that out. So the real due process would occur at the hearing itself, even if he or she doesn't avail himself of a settlement conference or negotiations.
Okay.
Okay, the one last item I wanted to bring up is this 100-day rule. And thank you to those who were able to participate in our special board meeting. We try not to have those. It just so happens some things slip through the cracks. And what the 100-day rule means is that once the ALJ makes a decision, we have a date, 100 days from the date he signs it. Essentially, the board has to decide whether they're accepting it or whether they're going to make their own decision. And so our special board meeting was called because the 100 days was going to end up on August 2nd. And obviously today is August 14, 15, whatever we are today. So that's why we needed to have that special meeting. Now the clock is stopped on that particular case, and the transcripts have been ordered. And we are hoping to have those transcripts in time to go ahead and disseminate to you prior to the November meeting so that you can then decide whether to uphold the proposed decision or whether Michael will assist you in drafting your own decision in that case. Are there any questions about that? I also just wanted to say that when we have a stipulated settlement and what's been happening with the board in some of the stipulated settlements that are held for discussion, the trend is to increase the penalty, and I believe that's appropriate. The board really hasn't decreased the penalty, which is a good thing. And so just to remind you that if you give a counter offer back, it may not be accepted, in which case that would get back on the docket and would go to hearing. So I don't believe we've had a case recently where the respondent has not accepted the board's counteroffer. So are there any questions? Want to try to get some of this nailed down because we're going into closed session just about now. And there may be some questions that come up in some of the things that you're going to be reviewing, and we'll have an opportunity to discuss that further.
Yeah, I just wanted to kind of maybe add one other thing, is that kind of in line with what we were talking about before with the hold for discussion. If there's 15 people voting, even if, 8 vote yes and, one, I guess we're not all voting, but whatever the number is, if one voted reject and one voted hold for discussion, I just want to maybe clarify for everyone that that would not get held, because right now we require 2 hold, and a reject doesn't hold it for a discussion, so that it would get accepted. So just to remind people the difference between a reject and a hold for discussion.
And she's right. She's absolutely right.
And that actually was one of the things that I was going to ask. And maybe to understand better if there is some reason that people choose that option. Is it because they don't understand the other options? Steve?
In one of the cases before us, the public member asked, I need some more information from the dental experts.
But she didn't reject it.
She didn't reject it, but she wanted to hold it for that reason.
Right. But I think what I'm trying to understand is what is it that I am missing that instead of holding for discussion, people will say, I want to reject this. Anybody?
Right, we rarely get a majority of people that just flat out reject. So I guess at this point, it's an open-ended question, because I don't know that we would want to put anybody on the spot. But I think what Ms. McKenzie was saying is, if you're saying non-adopt or reject, that it's likely you should probably be saying, let's hold for discussion. That's the cleanest way, I think, to say that. And if anybody in particular has questions, you can always call me, and we can talk it through if you're the slightest bit confused. So.
Didn't you have some, no? You okay?
No, we covered it.
Okay,
Thank you.
okay,
Thank you.
okay. This is good. This is very good. I would say, and the only thing that you wouldn't cover here is something that has bugged me from the entire time I've been on the board, and that is the DAG that always leads with, this is the first time this person has been before the board. That means nothing to me. I equivalent that, I equate that to somebody getting a jaywalking ticket. It's probably not the first time they jaywalk. But it's to me, it's not it's not even a factor to be considered, but yet because it's such a boilerplate term, it's as if it is.
Well, I'm going to be working with drafting the new recommendation for the transmittal letter that the Deputy Attorney General send. It's been interesting to find out that since our 2 discipline coordinators have been gone, some of the DAGs didn't realize that our analysts weren't making the decisions or weren't giving the settlement terms. I mean, I just thought everybody knew that essentially those are coming from me, and whether I'm having a direct conversation with the DAG or whether I'm relaying the information in writing to an analyst who's passing it on, apparently there was some confusion on their end. So I'm preparing, the Attorney General's office has what they call the book for each board and bureau, and so we're going to be revising that. We are in the process of recruiting for the discipline coordinators, and so that's coming quickly. So we're going to get that up and running, but I'll say this, it's been fun to do it for a little bit, do everything. I mean, do the emails, have the telephone conversations, but obviously I need some assistance in doing that, and that's why we have the discipline coordinators to be able to relay certain information. So the transmittal letters you've said in the past have usually been addressed to Adrian or Jocelyn, and it's more likely they should be addressed to me as being the person who proposed the settlement terms, and it should say that we need to bring this now to the board for their final decision. We'll clarify those things. I think they're clerical things that we can get back on track soon. That concludes this agenda item for me, unless anybody has additional questions.
Public comment? Okay, seeing none. We are now going to recess into closed session. And let me just announce for those of you who will be leaving the room, we're going to dinner. If you will, meet in the lobby at 6 p.m.